Hi, everybody. Welcome back to Patriots History. I'm Larry Swikart, the co-author of Patriots History of the United States with Michael Allen, also the host of this program. We are now in lesson 112. Whoa, can you believe it? It seems like only yesterday I started these. And you're currently in chapter 8, House Dividing, and we are under the topic of the Dred Scott decision. And as always, when I come to a document that we reference in the book, kind of highlight reference, not everything we cite, but kind of a highlight, I try to read the actual document. So I've been reading through the Dred Scott case, and last time we got about halfway through it. It's a very long-winded decision. So we're going to continue now. I'm reading from the Patriots History Reader, the companion to Patriots History United States. And this is, of course, the Dred Scott case, and I am on page 147, first full paragraph. Now, last time, let me just bring you up to speed here. Last time, Justice Taney said that slaves could never be citizens because citizenship was a right of the state. Well, New York already had made citizens of slaves. So had several other northern states. They held citizenship and could vote in state elections. Then Taney, I'm not sure if I'm taking the proper order, but because he's so goofy, but he then said that we need to emulate the Europeans. Europeans, you know, they would never tolerate this. Well, I'm sorry, they're Raj. England eliminated slavery in 1838. I think France eliminated about 10 years later. Spain didn't until 1870 something. So if we're going to emulate the Europeans, we should have abolished slavery, right? Raj. So then he goes back and says, no. The Europeans had it right when they didn't look at blacks as human beings. So that's simply not true. And in fact, there were a number of free blacks serving in various positions, certainly in the French military. Napoleon himself had an entire regiment of Mamluk guards. I don't think you'd want to tell those guys that they weren't humans. So Raj is all over the place here. He's having trouble. We're picking up on page 147, and this is Taney. So, too, a person may be entitled to vote by law of the state. Oh, really? Good for you to acknowledge that. Who is not a citizen even of the state itself. But the thing was, Raj, those blacks who voted in New York were citizens. And in some of the states of the Union, foreigners not naturalized are allowed to vote. And the state may give the right to free Negroes and mulattoes, but that does not make them citizens of the state. It certainly did. They were citizens first. That's what the states said. He's trying to have it both ways. He's trying to say that only the states get to decide who's a citizen, but the states who said that blacks are citizens, that's not right. They can't do that. I get real frustrated reading this. And still less of the United States. And the provision in the Constitution giving privileges and immunities to other states does not apply to them. Neither does it apply to a person who, being a citizen of a state, migrates to another state. For then he becomes subject to the laws of the state in which he lives, and he is no longer a citizen of the state from which he was removed. And the state in which he resides may then unquestionably determine his status or condition and place him among a class of persons who are not recognized as citizens but belongs in an inferior subject race, and may deny him the privileges and immunities enjoyed by his citizens. In essence, he's saying, okay, so if you're from Massachusetts and you're a free citizen of Massachusetts, but you happen to go to Alabama, they can re-enslave you because, well, they just can't. But so far as mere rights of person are concerned, the provision in question is confined to citizens of a state who are temporarily in another state without taking up their residence there. It gives them no political rights in the state as to voting or holding office or in any other respect. By the way, that is not true. How many times do you know in your home state or your hometown that university students vote in your elections? They can re-register there, then go back home and re-register there. For the citizen of one state has no right to participate in the government of another. But if he ranks as a citizen in the state to which he belongs, within the meaning of the Constitution of the United States, then wherever he goes to another state, the Constitution clothes him with the rights of the person with all privileges and immunities which belong to the citizens of the state. Now, he's kind of contradicting himself there. He's saying, well, if you're a citizen of one state, you get the rights and privileges of another state. That's called comity. We went over that before. It's the notion that one state has to obey the laws of another state insofar as is practicable to facilitate commerce, etc. And if persons of African race or citizens of a state and of the United States, would they be entitled to all the privileges and immunities in every state? And the state could not restrict them, for they would hold these privileges and immunities under the paramount authority of the federal government, and its courts would be bound to maintain and enforce them, the Constitution and laws of the state contrary notwithstanding. And if the states could limit or restrict them or place a party in an inferior grade, this clause of the Constitution would be unmeaning and could have no operation, would give no rights to the citizen when in another state. He would have none of what the state itself chose to allow him. This is evidently not the construction or meaning of the clause in question. It guarantees rights to the citizen, and the state cannot withhold them. And these rights are of a character and would lead to consequences which make it absolutely certain that the African race were not included in the name of the citizens of the state and were not in the contemplation of the framers of the Constitution when these privileges and immunities were provided for the protection of the citizen in other states. Baloney. Constitution, says nothing about skin color, period. Nothing. It doesn't say anything about slavery. It talks about persons in servitude. This was a business or a social construct that could be changed. It was not under those rights to life, liberty, pursuit of happiness, because the Constitution says that blacks were persons. No one, we presume, supposes that any change in the public opinion or feeling in relation to this unfortunate race in the civilized nations of Europe or in this country should induce the court to give to the words of the Constitution a more liberal construction in their favor than they were intended to bear when the instrument was framed and adopted. You don't have to, Raj. You just have to read the damn document. It says persons, not property. Persons. There's no different from one person from the next under the Constitution. Get it? If any of its provisions are deemed unjust, there is a mode prescribed in the instrument itself by which it may be amended, but while it remains unaltered, it must be construed now as it was understood at the time of its adoption. I agree. And you are understanding it wrong. You're going out of your way to understand it wrong. It is not only the same in words, but the same in meaning, and delegates in the same power to the government and reserves and secures the rights and privileges to the citizen. As long as it continues to exist in its present form, it speaks not only in the same words, but with the same meaning and intent which it spoke when it came from the hands of the framers and was voted on and adopted by the people of the United States. Which words are those, Roger? You're using the word slave. They use the word person. Unfree person, but person. Any other rule of construction would abrogate judicial character of this court and make it a mere reflex of popular opinion and the passion of the day. This court was not created by the Constitution for such purposes. Higher and graver trusts have been confided to it, and it must not falter in the path of duty. What the construction was at that time, we can hardly admit of doubt. We have the language of the Declaration of Independence. All men. That language, Raj, all men. Not all white men. All men. You have trouble with that, don't you? And the Articles of Confederation, which prohibited slavery in the Northwest Territory. In addition to the plain words of the Constitution itself, persons. We have the legislation of different states before and about the time and since the Constitution was adopted. And we have different readings of constitutions from different states. It's your job to make sure they all sound the same and look the same. We have the legislation of Congress from the time of its adoption in the recent period, and we have the constraint, which, by the way, it continued to prohibit slavery in the Northwest Territory lines, except by special exception in Missouri. And if by anything in relation to the construction of the Constitution can be regarded as settled, it is that which we now give to the word citizen and the word people. We'll try the word persons. You haven't addressed that yet. And upon a full and careful consideration of the subject court of its opinion upon the facts stated by the plea in abatement, Dred Scott was not a citizen of Missouri within the meaning of the Constitution of the United States, and not entitled to sue in its courts, and consequently that the circuit court had no jurisdiction on the case, and that the judgment and plea in abatement is erroneous. The case before us still more strongly imposes upon this court the duty of examining whether the court below has not committed an error in taking jurisdiction and giving a judgment for costs in favor of the defendant. For in Capron v. Van Noorden, the judgment was reversed because it did not appear that the parties were citizens of different states. They might or might not be, but in this case, it does appear the plaintiff was born a slave, and if the facts upon which he relies have not made him free, then it appears affirmatively on the record that he is not a citizen, but he is a person. And consequently, his suit against Sanford was not a suit between citizens of different states, and the court had no authority to pass any judgment between the parties. The suit ought to, in favor of it, been dismissed by the circuit court, and its judgment in favor of Sanford is erroneous and must be reversed. It is true that the result, either way, by dismissal or by judgment for the defendant, makes very little, if any, difference in a pecuniary or personal point of view to either party. But the fact the result would be very nearly the same to parties in either form of judgment would not justify this court in sanctioning an error in the judgment, which it was patent on record, and which, if sanctioned, might be drawn into precedent and lead to serious mischief and injustice in some future suit. Now we get back to the fact that the lawyers for Dred Scott screwed up by not taking the Mary Scott case first, because she was clearly free and she was married, and the right of marriage is something that a free person holds. In other words, Scott was already exhibiting characteristics of a free person. We proceed, therefore, to inquire whether the facts relied by the plaintiff entitled him to his freedom. In considering this part of the controversy, two questions arise. Was he, together with his family, free in Missouri by reason of the stay in the territory of the United States therein before mentioned? And two, if not, is Scott himself free by reason of his removal to Rock Island in the state of Illinois, as stated in the above admissions? We proceed to examine the first question. An act of Congress upon which the plaintiff rules declares that slavery and involuntary servitude, except as a punishment for crime, shall forever be prohibited in that part of the territory ceded by France under the name of Louisiana, which lies north of 36 degrees 30 minutes north latitude and not included in the limits of Missouri. And the difficulty which meets us at the threshold of this part of the inquiry is whether Congress was authorized to pass this law under any of the powers granted to it by the Constitution. For if the authority is not given by that instrument, it's the duty of this court to declare it void and inoperative and incapable of conferring freedom upon anyone who is held as a slave under the laws of one of the states. The counsel for the plaintiff has laid much stress upon that article in the Constitution that refers to Congress on the power to dispose of and make all needful rules and regulations respecting the territory or other property belongings in the United States. But in the judgment of the court, that provision has no bearing on the present controversy, and the power therefore given, whatever it may be, is confined in what was intended to be confined to the territory at which time it belonged to or was claimed by the United States and was within the boundaries as settled by the Treaty of Great Britain. It can have no influence upon a territory afterwards acquired from a foreign government. It was a special provision for a known and particular territory and to meet a present emergency, nothing more. That brings us to examine by what provision the Constitution, this thing is so long, we'll get it. Present federal government, under a delegated and restricted powers, is authorized to acquire territory outside the original limits of the United States, and what powers may exercise therein over the person or property of the citizen of the United States, whether it remains a territory and until it shall be admitted as one of the states of the Union. There's certainly no power given by the Constitution to the federal government to establish or maintain colonies bordering on the United States or at a distance, to be ruled and governed at its own pleasure, or to enlarge its terminal limits in any way except by the admission of new states. Well, yeah, that's what the Northwest Ordinance was all about, you dummy. It set up territories to become states, but all territories have not yet become states. Arizona waited a long time to become a state. That power is plainly given, and if a new state is admitted, it needs no further legislation by Congress because the Constitution itself defines the relative rights and powers and duties of the states and citizens of the state and the federal government. But no power is given to acquire a territory to be held and governed permanently in that character. Wrong. Northwest Ordinance makes it very clear. Congress has authority over the territories until they submit an article of Constitution to the Congress. What is so dense with this guy? And indeed, the power exercised by the Congress to acquire territory and establish a government there, according to its own unlimited discretion, was viewed with great jealousy by the leading statesmen of the day. And in the Federalist number 38, written by Mr. Madison, he speaks of the acquisition of the Northwestern Territory by the Confederated States by the cession from Virginia and the establishment of the government there as an exercise of power not warranted by the Articles of Confederation and dangerous to the liberties of the people. But they voted on it. It doesn't matter what Madison thought of it. And he urges the adoption of the Constitution as a security and safeguard against such exercise of power. Well, he urged it as an exercise to guard against an exercise of power such as you are now doing, Raj. We do not mean, however, to question the power of Congress in this respect. Of course you do. Power is to expand the territory of the United States by the admission of new states is plainly given, and in the construction of the power by all the departments of governments that have been held to authorize the acquisition of territory not fit for admission at the time, but to be admitted as soon as its population and situation will be entitled to admission. True. Is acquired to become a state and not to be held a colony governed by Congress with absolute authority, and as the property of admitting a new state committed to the sound discretion of Congress, the power to acquire territory for that purpose to be held by the United States until a suitable condition is to become a state upon being equal footing with other states must rest upon the same discretion. It is a question for the political department of government and not the judicial, and whatever the political department of government shall recognize within the bounds of the United States, its judicial department is also bound to recognize. He's admitting here that Congress is right. They have the authority to create the Northwest Ordinance and to expand freedom as far as they want, and to maintain in the territory the authority and rights of the government and also the personal rights and rights of property of individual citizens as secured by the Constitution. All we mean to say on this point is, as there is no express regulation in the Constitution defining the power which general government may exercise over the person or property of the citizen in the territory thus acquired, the court must necessarily look to the provisions and principles of the Constitution and its distribution of powers for the rules and principles by which its decision is governed. This is gobbledygook. Saying, well, we need to obey the Constitution, but we got to look at the Constitution. Taking this rule to guide us, it may be safely assumed that citizens of the United States who migrate to a territory belonging to the people of the United States cannot be ruled as mere colonists, true, dependent upon the will of the general government, and to be governed by any laws they think proper to impose. The principle on which our governments rest and upon which alone they continue to, he just validated the whole Missouri Compromise. I don't know what he thinks he's doing here. That is a strict admission that the Missouri Compromise was a legal and constitutional act. Principle upon which our governments rest and upon which they continue to exist is the union of the states, sovereign and independent within their own limits and their internal and domestic concerns, and bound together as one people by a general government possessing certain enumerated and restricted powers, delegated to it by the people of several states and exercising supreme authority within the scope of the powers granted to it throughout the dominion of the United States. A power, therefore, the general government to obtain and hold colonies and dependent territories over which they might legislate without restriction would be inconsistent with its own existence and in its present form. No, you just said the opposite. It is precisely what the government had in mind, that only Congress would have authority over the territories. Whatever it acquires for the benefit of the people of the several states. Oh, wait. Listen to this. Whatever it acquires for the benefit of the people of the several states who create it, not for the benefit of the states. You see what this idiot is doing? He's jumping back and forth between trying to say that the people totally need to govern the acquisition of territories because the Constitution is an instrument created by the people. And yet when he wants to, he jumps back and says, oh, no, the states created the Constitution. You can't have it both ways. Okay. Territory being a part of the United States, the government and citizen both enter it under the authority of the Constitution with their respective rights defined and marked out, and the federal government can exercise no power over his person or property beyond what the instrument confers, nor lawfully deny any right which has been reserved. There is no right to slavery in the Constitution, period. There is no right to slavery. The Constitution talks about unfree persons, but the Congress can make them free. Reference to few of the provisions of the Constitution will illustrate this provision. For example, no one, we presume, will contend the Congress can make any law in the territory respecting the establishment of religion or the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people of the territory to peaceably assemble and to petition the government for the redress of grievances. Nor can Congress deny to the people the right to keep and bear arms, nor the right to trial by jury, nor compel anyone to be a witness against himself in a criminal proceeding. Now, you know what's interesting about all the things he just noted? They were recognized by every single one of the states. You're right. We all have freedom of speech, freedom of religion, blah, blah, blah. You'll notice that one right, so-called right, was not recognized by all the states: the right to own other people. These powers and others in relation to the rights of the person, which it is not necessary to enumerate here, are in express and positive terms denied to the general government, and the rights of private property have been guarded with equal care. So now we get to it. Is a slave a piece of property? Thus, the rights of property are denied by the rights of the person placed in the same ground by the Fifth Amendment to the Constitution, which provides that no person shall be deprived of life, liberty, pursuit of property without due process of law. Okay, you're getting somewhere now, Raj. Now go back to that clause where it defines slaves as persons. You just said, no person shall be deprived. And yet the Constitution calls slaves persons. How can you deprive them of their liberty? And an act of Congress which deprives a citizen of the United States of his liberty or property, nobody was denying anybody their right to property, because a slave was a person. See how he's got himself twisted in a knot? Merely because he came himself or brought his property into a particular territory. No, he brought a person in a particular territory of the United States who had committed no offense against the laws, could hardly be dignified with the name of due process of law. So too, it will hardly be contended that Congress could by law quarter a soldier in a house in a territory without the consent of the owner in a time of peace or in time of war, but in manner prescribed by law, nor could they by law forfeit the property of a citizen in a territory who is convicted of treason for a longer period than the life of the person convicted, nor take private property for public use without just compensation. Powers over person and property of which we speak are not only not granted to Congress, but they are in express terms denied. They are forbidden to exercise them. And this prohibition is not confined to the states, but to the words are general and extend to the whole territory over which the Constitution gives it power to legislate, including those portions of it remaining under territorial government, as well as that covered by the states. It is a total absence of power everywhere within the dominion of the United States and places citizens of the territory, so far as these rights are concerned, on the same footing with citizens of the states, guards them firmly and plainly against any inroads which the general government might attempt under the plea of implied or incidental powers. And if Congress itself cannot do this, it is beyond the powers conferred on the federal government. So he's not only, this is important, almost all textbooks will agree that Taney overthrew the Missouri Compromise. No, he did far more than that. He overthrew the Northwest Ordinance. He overthrew the very basis of the entire American territorial system, saying Congress does not have the authority to create states. This guy's a lunatic. Should have been ridden out of the court on a rail. And Congress itself cannot do this. It is beyond the powers conferred on the federal government. It will be admitted, we presume, that it could not authorize a territorial government to exercise them. It could confer no power on a local government established by its authority to violate the provisions of the Constitution. It seems, however, to be supposed that there is, which, by the way, let me go back to that. In other words, without realizing it, Taney is saying that if you define a slave as a person, in the Northwest Territory, in the free territories of the Missouri Compromise, you must define slaves as persons in the South. He didn't realize he said that, but that's just what he said there. Now, he's not, of course, going to go along with that, but that's what he said. It seems, however, to suppose that there's a difference between property and slave and other property. Yes, there is, because of the word persons, and that different rules may be applied to it in expounding the Constitution of the United States and the laws and usages of nations and the writings of the eminent jurists and the relation of the master and slave and their mutual rights and duties. And we already noted, by the way, the Dorsetshire case, Somerset case from England, which was precedent that said that you can't hold slaves. And the powers which governments may exercise over have been dwelt upon in the argument. But in considering the question before us, it must be borne in mind that there is no law of nations standing between the people of the United States and their government and interfering with their relation with each other. That's true. The powers of the government and the rights of the citizen under it are positive and practical regulations plainly written down. That's true, including the words persons. People in the United States have delegated to it certain enumerated powers, forbidden it to exercise others, as no power over the person or property of a citizen, but what the citizens of the United States have granted, no laws or usages of other nations or reasoning of statesmen or jurists upon the relation of the master and slave. He's trying to say, well, that keeps saying Dorsetshire, it's Somerset. Somerset case has no bearing here. Of course it does, because it was a basis long before there was a Constitution of the United States. In other words, we accepted plainly English law that was not expressly prohibited. We said, yeah, what they're doing, that was right. And if the Constitution recognizes the right of property in the master of the slave and makes no distinction between that description of property and other property owned by a citizen, no tribunal acting upon the authority of the United States, whether it be legislative, executive, or judicial, has a right to draw such a distinction or to deny it the benefit of the provisions and guarantees which have been provided for the protection of private property against encroachments of government. Except you never once get back to that phrase about persons in servitude. Persons, persons, persons. Sorry, Raj. I don't have a law degree and I can figure this out. Now, as we've already said in the earlier part of the opinion, upon a different point, the right of property in a slave is distinctly and expressly affirmed in the Constitution. No, it is not. The right to hold a person in servitude, that is, in terms of work. Big difference. The outcome may be the same, but there's a big difference because one is a human being and one is a chair or a cow. The right to traffic in it, like an ordinary article of merchandise and property, was guaranteed to citizens of the United States in every state that might desire it for 20 years. So what? For 20 years, they were wrong. And the government in express terms is pledged to protect it in all future times. No, it's not. If a slave escapes from his owner, this is done in plain words, too plain to be misunderstood. No word can be found in the Constitution which gives Congress greater power over slave property, or which entitles property of that kind to less protection than property of any other description. Sure it does. The word person, that changes everything. The only power conferred in this power, you notice he never once gets to that issue. The only power conferred is the power coupled with the duty of guarding and protecting the owner and his rights. Upon these considerations, the opinion of the court that the act of Congress which prohibited a citizen from holding power and holding and owning property of his own kind, of this kind, in the territory of the United States north of the line therein mentioned, is not warranted by the Constitution, is therefore void, and neither Dred Scott himself nor any of his family were made free by being carried into the territory, even if they had been carried there by the owner with the intention of becoming a permanent resident. So it doesn't even matter if he wanted to become a permanent resident. Still wouldn't count. We have so far examined the case as it stands under the Constitution of the United States and the powers thereby delegated to the federal government. But there's another point. Oh, yeah, of course there is. In case which depends on state power and state law, it is contended on part of the plaintiff that he is free by being taken to Rock Island, state of Illinois, independently of his residence in the territory. The United States being made free, he was not again reduced to a state of slavery by being brought back to Missouri. Our notice of this part of the case will be very brief, for the principle on which it depends is decided in this court upon much consideration in the case of Strader et al. V. Graham. In that case, the slaves had been taken from Kentucky to Ohio, with the consent of the owner and afterwards brought back to Kentucky. And this court held that their status or condition as free or slave depended upon the laws of Kentucky, where they were brought back into that state, not of Ohio, and that this court had no jurisdiction to revise the judgment of the state court upon its own laws. This is the point directly before the court, and the decision that this court had not jurisdiction turned upon it, and will be seen by the report of the case. So in this case, as Scott was a slave when taken into the state of Illinois by his owner, was held there as such, was brought back in that character, his status free or slave depended on the laws of Missouri, not of Illinois. He probably has a better case there, except for the person clause, but that's probably his best argument yet. It has, however, been urged in the argument that the laws of Missouri he was free upon his return, and that this case, therefore, cannot be governed by this case of Strader v. et al. V. Graham, where it appeared by the laws of Kentucky that the plaintiffs continued to be slaves upon their return from Ohio. But whatever doubts or opinions may at one time have been entertained upon this subject, we are satisfied on a careful examination of all cases decided in the state courts of Missouri referred to, that is now firmly settled by the decision of the highest court of the state that Scott and his family upon their return were not free, but were by the laws of Missouri the property of the defendant, and that the Circuit Court of the United States has no jurisdiction when, by the laws of the state, the plaintiff was a slave and not a citizen. In other words, you're out of luck, Dred Scott. Now, the reality was, by this time, Dred Scott was free, could not be re-enslaved anywhere, and so it was a Pyrrhic victory for Taney, but it did set up the incredible outrage across the country that the high court was totally corrupt and was in the hands of what was then called the slave power conspiracy. And Lincoln would talk about this at length. So, but it's going to go further than that, because if you wanted to run for president, as Stephen Douglas did, you were going to have to say that the Dred Scott decision was correct. But that wasn't going to fly in the North. And so how can you run for president if you need the majority of votes, which are in the North? How are you going to do that? As we will see, Douglas concocts an incredibly stupid answer, and it costs him the presidency. But we'll get to that. Now, next time, I'm going to continue reading from the Reader on Dred Scott, and this is by Frederick Douglass, and address. Oh my gosh, this is also really long. Holy cow, these guys just didn't shut up. All right, we'll have to take that one in two parts as well. So we'll start next time with on Dred Scott, Frederick Douglass, 1857, part 1, maybe part 1 of 3. I'll see you guys back here next time. And remember, Patriot's History of Globalism is now out. Grab your copy. Also, in about a week, anyone who is already a member of the VIP on Wild World of History or Insider on Wild World of Politics will get free my 20th anniversary edition of Patriot's History of the United States. It consists of a PDF with a brand new chapter, but also many, many, many pages. I don't know, 15, 20 pages of new material, new insertions that you would plug in when going through this paper edition, Patriot's History of the United States. We can't put out a whole new book, but you will get the PDF with the new chapter and all the changes and where they go. And there's 2 or 3 corrections that go in there too. Those will be made available free as a gift for being a VIP on the Wild World of History or an insider in the Wild World of Politics. If you aren't a member, join up. Only $6 a month, $69 a year for either. If you're more interested in politics, and I do Larry's commentary 3 days a week, take the Insider. If you want more historical stuff, blogs for your kids, stuff to read, videos that are more history-oriented, though many of the videos on both sides are the same. VIP has Churchill Integrity. The Wild World of Politics has an exclusive, which is Globalism Then and Now video series, which have about 15 or 20 videos in them. So take your pick, but if you get either one, you get free the download of Patriot's History of the United States 20th Anniversary Edition. And don't forget, I need your help turning this into a film. We're very close. We've got people lined up now to put in almost all the money. Just buy Larry a copy. If a few hundred of you did that, we'd make this film tomorrow. Okay, I'll see you guys back here on Wednesday.